Okay, it's October 27th, 2025. This is section 1 of Admiralty Law, and we are going to talk about the material in Module 11 today, which is kind of called Advanced Considerations in Collision. That's a title that makes sense because it relates to this collision case we're studying, and it relates to all kinds of aspects of the law that deal with finding fault of a party and who's responsible and what happens if you appeal that decision and what does the appellate court do. But it's not just related to collision, it's related to the law in general. So I'm going to begin by introducing the concepts, and then I'm going to, toward the end, explain how they relate to that collision case we talked about. There's a handout, which I wrote some years ago, and it's really, I used to give it as a paper handout, 2 sides of 1 page, and it's proximate cause, or causation, really. It's entitled Causation, and the other one is standard review. And one is on one side, and one is on the other side. And at first, they don't even seem to be related, but you're going to see how they are. We're going to start with, obviously, this side, causation. If somebody causes something, they should be responsible, right? That's the idea of negligence or intentional acts of harm. The idea is if you cause somebody damages, you're held accountable, and you have to pay. We can imagine how that works in the law, but there is obviously going to be some limitation to how far down the line of causation somebody can be held accountable. I'm going to give you an example. I'm actually going to erase everything on the left side of the board now. No, I don't have to erase anything. Yeah, I will erase it. We need more room. Let's do it with a collision or an allision example. An allision being where you hit a stationary object. So imagine you have a bridge, and cars are going up to the bridge, and the traffic is going across the bridge, and it's going both ways, obviously in separate lanes. So you've got activity, you've got the water down here, you've got the bridge. You know, this happened in May of 1980, and it happened again last year in Baltimore. Vessels sometimes hit bridges. And when a vessel hits a bridge, we'll go with the Sunshine Skyway Bridge, May of 1980, because that had a lot more damages in terms of human life loss than what happened with the Dolly in Baltimore. Sunshine Skyway Bridge was hit in heavy fog in May of 1980, and it basically cut the bridge in half. Pretty disastrous maritime casualty, and you had cars falling into the water and people dying. I believe 11 people died, and there was one classic case of a car hanging right on the edge and not quite falling into the water, and those passengers and driver lived. There was another one where they went into the water and somehow got out and survived, but most of the people who went into the water in their cars died. You also had obvious damage to the bridge itself, and then you had all kinds of other damages that you can imagine that were all caused by this incident, right? So, the question becomes, of all those possible damages, how many of them, which types, get to be rewarded or given compensation for their injuries? And I'm going to set this up as a series of examples. First off, you have the deaths. Let's take the human life one first, right? The bridge gets cut in half by the ship. Somebody wants to sue the vessel interests, vessel in rem maybe, or it could be the vessel owners, depending on that pilotage situation, which we talked about in the past, you know, compulsory or not. I want you to review that at some point, not now. But the vessel might be liable, or the vessel owner might be liable. Theoretically, the pilot could be liable, but the pilot has no assets, so you're not going to get any money. But the bottom line is we're just going to talk about suing the vessel interest for the damages that occurred to these various potential plaintiffs. So the human lives. If not for the bridge being cut in half, it's overwhelmingly likely that these people would not be dead now, right? So as a matter of factual cause, they definitely were killed as a result of the vessel's action. Call it negligence, call it whatever you want. But the vessel cut the bridge in two, the cars plummeted into the water, and people died. We know as a matter of causation, we can't say, oh, they might have died anyway. The guy driving across the bridge might have had a heart attack on his way, so you can't hold the bridge, the vessel accountable. That's bordering on the ridiculous. So we say, but for the vessel's tort, but for the vessels hitting the bridge, these people would still be alive. And that's a reasonable proposition. You know, you could always argue, yes, but something else could have caused them to die. But when it borders on the ridiculous, you have but-for causation. But for, if not for, the vessel cutting the bridge in half, these people would be alive today. So clearly, there is factual causation as to their deaths. And now the question is it the kind of chain of causation that the law will reward? Should they be able to recover for their deaths, or is it too far removed from the scene, too many steps in causation? Well, obviously, they're right there. So there's no doubt that they would be able to recover, assuming their cases had merit, which they probably did, and assuming the vessel could be sued, which it could in one way or another, they're going to be able to recover. The distinction there is between factual causation and proximate causation. Now, it's kind of interesting. This proximate cause thing is a legal concept. This is kind of a logical concept, but the proximate cause thing is a legal concept. What does it mean? You have to have factual causation before you can have proximate causation. But proximate causation is really a judgment that's made by the court as to whether the chain of events is close enough, connected enough, to hold the tortfeasor responsible. In other words, and I'll give you some examples where we're going to question whether that would happen, but here, the deaths, clearly there's factual cause. If not for the bridge being cut in half by the vessel, these people would be alive. There's proximate cause because they were right there. There's no long chain of causation of events that a judge would say, oh no, that's too far removed. Who would expect that this harm would occur? How can these plaintiffs recover? Yes, they died. They can recover, or their estates can recover. Their estates can recover. Okay, the bridge itself. Does the bridge owner have a cause of action against the vessel? Sure. You know, right there. The vessel, the bridge would be whole if the vessel hadn't cut it in half. So that's another example where there's both factual cause and proximate cause. Now let's get into some hypotheticals. This guy right here is on this side of the bridge. And this is a little van that has several people from a law firm. I'll make it a law firm. And there's a partner, there's an associate, there's some paralegals. They've got a bunch of presentation material. They're on their way over here to meet the CEO of a big company, and she has her assistants, and they're going to meet at this conference center at noon for a working lunch to see if this law firm is going to get the work that they have. And this meeting has been planned for months, and there's been a lot of preparation on both sides, and they left plenty of time to get there. They got to be there by noon. They're on the road at 9 a.m. They're going to get there with time to spare, set up their presentation at the center, do their pitch, and if they succeed, which they likely will, let's just make that part of the facts, they're going to get the gig if they show up. They're all prepared, they're going to get the gig. It's worth $100,000 over the next year. Pretty serious. Then they're on their way over, bridge gets cut in half. There they are 3 hours early. Can't turn around, can't go forward. Stuck on the bridge till 2 in the afternoon. Let's make it 1980 when it happened. This actual scenario didn't happen, but the bridge in Tampa got cut in half in 1980. How many cell phones were around in 1980? Anybody have a cell phone in 1980? Anybody here alive in 1980? Maybe a couple of people, one person, two, me. I'm sorry, I'm on video, no targeted comments. So anyway, they're stuck there, they can't do anything about it, and they lose the $100,000 contract. And let's assume for purposes of this exercise that had they made the meeting, they would have gotten the contract. They have been damaged to the tune of 100,000 or whatever percentage of profit would have been made by the thing. But let's just assume that for purposes of fact, they would have made it to this meeting, they would have gotten the gig, and they lost it. And it was all because this bridge was cut in half, when it was cut in half, denying them the opportunity to participate in that meeting. Would you say there's factual cause? But for the bridge being cut in half, they would have made the meeting and gotten the gig? I basically already said all the facts line up to that. We can assume those facts are there. If not for the bridge getting cut in half, they would have made it to the meeting. They were there at 9 a.m., blah, blah, blah. They couldn't do it because they couldn't turn around and they're stuck on the bridge for 4, 6, 8 hours, whatever. You know, they couldn't walk back because security said, no, people can't walk on the bridge, it's too hazardous, stay in your cars for your own safety, people, stay in your cars, right? So they're stuck, and they lose their $100,000 gig. And let's assume that if they made it, they would have gotten it. So factually, if not for the bridge being cut in half, they'd get their money. They'd recover, not recover, but they'd have they'd have something coming in that they no longer have, that contract. Will the law allow them to recover that? Will the judge say, well, you've shown that if this accident hadn't happened, you would have made it to the meeting, and you've shown that you would have gotten the gig because there were no competitors that could have done as good a job, and you've shown that it was worth $100,000, so yes, your case can proceed. I would say most judges would say no, but it's possible that it might be a yes. But this is where proximate causation comes in. Proximate causation is a filter through which factual causation is passed to see if you get to stay in the game, to see if you get to stay in court. And the law is full of these filters that keep plaintiffs out. We'll talk about more of them later. But this is a very important one because you have to think about it in a special way. Factual causation really is a question of fact. You know, did it or did it not cause the thing? And, you know, the way it's often expressed is but for causation. B-U-T space F-O-R. But for this event, but for event A, event B would not have happened. And again, sometimes you can come up with all kinds of arguments about, well, something else could have caused it. You know, the deaths weren't caused because he could have died of a heart attack had he not fallen off the bridge. That's the ridiculous stuff. But generally speaking, but for causation can be established as a matter of fact. But for the bridge being cut in half, these people would be alive. But for the vessel hitting the bridge would be whole. But for this delay occurring because the bridge was cut in half, they would have gotten their contract. So you can say there's factual causation. But then, judgment enters into the picture. Judgment by a court, meaning a judge or a panel of judges, that decide, is this chain of events closely connected enough to allow the plaintiffs to recover? Even if all the facts line up in their favor, should we allow the law to reward them, to give them compensation for something that was that removed? One of the things that's often used is, how foreseeable was it that such a thing could happen? But again, these are just words and arguments. It's pretty foreseeable that if somebody's on their way across a bridge and they're relying on the bridge to be there, and they miss it, they won't make, you know, and the bridge gets cut in half, they'll miss the appointment. They won't. That's pretty foreseeable. So one could argue that a court should recognize proximate causation here. So we're not going to have to take a vote. I do that sometimes with this exercise. But you can see how is judgment involved, right? There's clearly cases where factual cause leads to cause. The deaths, the cutting of the bridge. Now we've got something where there's kind of a remote connection between event A and event A is the bridge is cut, event B is the delay, event C is the thing that would have happened here, and you can see it's kind of stretched out. So many times a court would say no proximate cause. You know, you were harmed, terrible thing, but we're not going to allow your case to proceed because even though there's factual cause, even though but for the event, everything would have been fine, we're still going to say we have to put a line in the sand somewhere and say there's a universe of plaintiffs we keep out. We can't have everybody. Okay, now let's assume that, in fact, this case would be allowed to proceed. Let's say the court decides that there is proximate cause, which is really just a judicial determination. It's just a filter between factual and whether or not you can proceed. So let's say the judge says, yes, this is close enough. So now we just take the hypothetical to a new level, and you see where sooner or later plaintiffs are going to get cut out. The next level is that there's another plaintiff here. It is the daughter of the principal of the law firm, who was 7 years old when it happened, and she was a very gifted piano player. And she was getting pretty expensive private lessons. And if she wanted to become virtuoso, world class, she would need to keep receiving those lessons because talent alone isn't going to do it. She really needed to keep receiving those lessons. But he lost that $100,000 contract, the firm lost it, could no longer afford those piano lessons. So now, she has lost her, chance to become a virtuoso piano player. And leave out the question of if 20 years go by, how you prove it. But think about it. Would that be the kind of thing where you would say, yes, this loss of funding was caused by this event because it denied the father the money to pay for the piano lessons, and she lost her ability to be a virtuoso piano player. So, but for this, she might have been a virtuoso piano player. Let's assume that she would have been, if not for this loss of the tuition money for the lessons. Would you think many courts would find proximate cause there? I think it would be impossible. I think any judge who found proximate cause for that remote an injury would be considered a lunatic, and it would be reversed on appeal because it's just too far removed. But the point I'm making here is that it's not really a black and white, clear, binary decision when it comes to this part. With this one, arguably it's closer to that. it either caused it or it didn't cause it, as a matter of fact. But here, something else comes into play. It's judgment. A court has to decide where to draw the line in this chain of causation. And that is one of very many, relatively many, filters, I call them filters, in the law. And you've already been introduced to some you probably don't even know. What do I mean by filters? They are things designed to keep cases out, or to keep plaintiffs out. Now, it's usually argued that it's supposed to serve justice, because the law shouldn't protect everybody for everything. And that's true, but it also serves the courts by keeping the caseload down, right? I had a mentor, John Garrity, passed away a few years ago, first firm I was at. He said, remember, Jim, it's not a system of justice, it's a system of order. Very important thing to remember. You're supposed to serve justice, the courts are supposed to serve justice, but really what they do is they administer cases and have order to the process. And if you have too many cases, which arguably the US already has in many systems, you will lose some of the order. It'll get a little chaotic. Most of the state courts are pretty overwhelmed in this region. The federal courts, we're doing okay. I've noticed some problems and backups thanks to the government shutdown, but we won't get into that for purposes of this course. In any event, the problem is that courts can't handle all the cases, especially in America. I mean, a very litigious society. So there are various doctrines, various methods to keep plaintiffs out, to keep cases out, to limit what can get in, you know? One of them is this, but I want to talk about some of the others to put it in perspective. One of the first ones we talked about, the first one we talked about, related to federal courts. How can a federal court keep you from getting in the first place? Remember I talked about two types of jurisdiction? Personal jurisdiction, and let's assume that's either a yes or no. There either is or there isn't. Personal jurisdiction over the defendant. And really, personal jurisdiction is not to keep the plaintiffs out. It lets the defendants out. But what about subject matter jurisdiction? Remember federal subject matter jurisdiction? If a judge has a basis to dismiss a case because there's no federal subject matter jurisdiction, they can exercise that and get rid of the case. So for example, let's say I want to bring a divorce action in the United States District Court for the Southern District of New York. I can't. The federal court has no subject matter jurisdiction over divorce. So one of the filters, in federal courts at least, is subject matter jurisdiction. In the first instance, there are only certain cases that could get in. We focused pretty much exclusively on subject matter jurisdiction under maritime or admiralty jurisdiction. There are other bases we talked about: diversity jurisdiction, citizen of one state suing another, subject matter arising out of federal statutes that grant it. By the way, limitation of liability statute is not one of those, but Age Discrimination and Employment Act, Title VII, they're all federal statutes that provide that the federal court has jurisdiction. But if the federal court doesn't have subject matter jurisdiction, that's one way for the judge to just toss the case right off the bat. So that's a filter. And of course it has justification legally and in terms of justice, but it also is a method of keeping cases out of court. The proximate cause thing is another such filter, a little bit farther down the line in terms of not as you get in the door. What about standing? We didn't talk too much, but standing is a doctrine that basically says if you don't have a special interest in that, the courts don't have to hear the case at all. And a lot of cases that get dismissed on standing because there are some things that bother everybody in general, but nobody in particular. So, you know, a lot of times these relate to taxes, things like that. We want the government not to do what it's doing with our tax money. Well, everybody wants the government not to do what it's doing with their tax money as to one of their activities or more, right? But if everybody could sue about that, oh gee, that would be a bit of a problem, wouldn't it? You know, my tax bill, money was used for this educational thing that I disagree with. My tax bill, money was used for war, and I don't like war. My tax bill, money was, you know, everybody would be a plaintiff. So there are a lot of things that, you know, there is no standing because the grievance is so general that nobody has a special different interest in the outcome. So we have this test called standing that keeps a lot of plaintiffs out of both the state and federal court. So those are two examples of filters. There is another one, and this is just an introduction to it, but in admiralty law, we're going to have a whole session on this in a couple of weeks. It's called the Robbins Dry Dock Rule, which basically keeps plaintiffs out if they either don't own the property that's involved or there's no physical harm to property they own. It's an interesting concept that has gotten a little out of hand. It comes out of a 1927 case, and the case doesn't actually say what the doctrine is. The case didn't stand for that doctrine. It didn't establish that doctrine. But lower courts over the years have kind of extended the case to create new law. Now, why can they get away with that and not be activist judges in federal court? Why can federal judges do stuff that other judges can't do in federal law? Why do admiralty judges in a maritime case get away with doing more? Why do they have extra leeway? Anybody? First class. What's different about admiralty law? Largely judge-made, right? Admiralty law has a history of being something that the judges created, and then we added the statutes to fill in the blanks. The interstices is what's sometimes called. But the real thing that's different about admiralty law from every other area of federal substantive law is that it begins with law that was made by judges. Law that was made by judges back in England before it came to the US. Law that was made in ancient codes in the Mediterranean, 1,000 years ago. Like maintenance and cure. It comes from way back then. And it's all part of this tradition of judge-made law. So judges in federal courts sitting in admiralty have a great moral latitude. And so they have created this rule in Robbins Dry Dock that if judges in any other area did it, they would be like, what are you doing? You're legislating from the bench. This is ridiculous. But they got away with it. And the Supreme Court didn't take it. Last time it was they had a chance, which happened to be my case, so I may have a little bit of an axe to grind here. But anyway, bottom line is that's another filter, the Robbins Dry Dock rule. But the filter we're talking about today is a pretty simple one. It's saying that even if there's factual cause, you may not have proximate cause. What's the difference? A judge, a judgment, a decision as to whether or not this is going to allow money to be recovered, or is it too far away? And I've given you a couple of hypotheticals. One is kind of on the borderline, but the daughter in the piano lessons, I don't think anybody would think that that was a case that could be allowed to proceed. Proximate cause is not there. I think everybody in the universe would agree that the poor daughter is not going to get her compensation for not being a virtuoso pianist because the money was lost when she was 7. It's just not going to happen. So, now, digest for a second, stop the camera for questions. And so now we've just covered this idea of proximate cause, and I said I was going to introduce how that relates to the collision case we studied. So, and then in terms of that, how does that relate to this idea I'm going to introduce called standard of review? So before I introduce standard review, let's talk about what happened in the collision case. In the collision case, you had 3 vessels, the Kariba, the Clary, and the Tricolor. The Kariba and the Clary were both going in a west-northwesterly direction in the English Channel in heavy fog, and nobody was sounding fog signals, and they were all going way too fast. Okay. A crossing vessel, the Clary, was up ahead and to Kariba's left, and held course and speed when it really should have come right and passed the stern of Kariba. The situation got more and more scary for the captain on the Kariba. He tried to get the Clary on the radio, no luck. He's being overtaken by this other vessel, he's worried about that. He's been on the bridge for 20 hours straight. They got a new collision avoidance system that he's just actually learning how to work. I do not envy the captain on the Kariba. He believed that it was a really dire situation, and he came right because he believed he was going to collide with Clary, the one that was crossing. In fact, as they went forward after making that right, and the fog, I wouldn't say lifted, but there was just less of it in between him and the ship, at the last seconds they saw that they were headed right for the Tricolor, which was the vessel that was overtaken. And they basically cut the Tricolor in half, and the Tricolor sank, and there were no lives lost. Everybody was rescued immediately by the Kariba and by other vessels in the area. Not the Clary just took off nothing. But there were other vessels. It was the English Channel, and everybody lived, so no deaths. But the vessel had millions of dollars worth of high-end BMWs and Mercedes vehicles on it, right out of the factory being shipped, and that was a total loss. So it was a pretty big case in terms of money. So the case comes to the U.S. Oddly to be here, but John Kimball, the lawyer for Otal Investments, the owner of the Kariba, decided to bring a limitation action in New York, which then became the springboard by which a federal judge in New York could determine all the fault issues in the collision. And that's what happened. So here we are. Everybody presents their evidence. It's clear what happened. Kariba came right at the last minute, feeling that there was an emergency situation, and cut the Tricolor in half. Now, bear in mind, none of the vessels were sounding fog signals. Kariba was being overtaken by the tricolor, much too close and much too fast. Clary didn't even have a lookout, it turned out on appeal that they even altered their logbooks after the fact, which the Second Circuit didn't like. But just on the merits alone, one could argue that as a matter of judgment, and I won't call it proximate cause here, but we'll get to that in a minute. As a matter of judgment, you could say, well, gee, everybody contributed to this. You know, if it wasn't for the high speed and close overtaking of Kariba by tricolor, you know, here's Kariba, here's tricolor, and they're overtaken. If not for that, tricolor wouldn't have gotten hit. Tricolor could have gone slower, could have left more room, could have not overtaken at all, given it was heavy fog. And you know, Clary bore some responsibility because Clary, you know, didn't have a lookout, wasn't sounding fog signals, was going too fast, and didn't even, you know, probably didn't have anybody on the bridge to answer the radio call. And certainly they created the vexing situation that led to the Kariba captains making that last-ditch move. So one could say that everybody had, you know, some responsibility. On the other hand, you could argue that Bear got it 100% right because all Kariba had to do was slow down. Because here's the situation, you got a vessel crossing ahead, you got another vessel overtaking you, you're kind of caught in the middle. Well, if you just slow down, the other vessel will overtake you, that vessel will cross ahead, and you just, you know, instead of doing 15 knots, you do 10. No brainer, right? Judge Bear, not even a, you know, doesn't even have a mate's license, but he figured that out. It's a lot easier to figure these things out, by the way, in court years later than it is on the bridge in the moment. Hindsight is 20/20. So, you know, it's difficult to say, oh, the Kariba captain got it wrong, he should have slowed down. It's easy to say that, it's not difficult to say. It's easy, though, to understand why the situation unfolded differently and how the other actors played a role in it. Okay, so I guess my point here is reasonable minds can differ as to how to apportion fault in this thing, depending on whether you take this perspective of the last one who had a clear chance to avoid it, we're going to hold them completely responsible, because if they'd done the right thing, everything would have been fine. Or you could say, well, they were put in a situation where it was dire straits and they made a mistake, but it was caused by all these other factors that led to it. So you can look at it both ways. So reasonable minds can differ. So now here's the thing. Everybody remember what I predicted in the article? What did I say was going to happen? The end of the article, which everybody read. Yes?
You said they were going to uphold it? Uphold the original?
Exactly. A student has said I predicted that the Second Circuit would uphold or affirm the decision below, and I did. And in fact, I commented in the article why. And I said, because I watched the oral argument and nobody there at all mentioned standard of review. Every time you go to appellate arguments, certainly in your briefing, you have to discuss, you have to tell the appellate court what the standard of review is. What does that mean? Well, now is where we get into that other thing. It's the flip side of my handout. Standard of review is the standard that an appeals court applies to the findings of the court below, right? And it's different depending on what kind of findings they are. If they're findings of fact, they apply one standard. If they're findings of law, they apply a different standard. Now, Judge Bear, he got to apply both fact and law. He got to determine the facts and to determine the law. But logically, those findings should be treated differently, parsed out and separated by the appeals court, right? The findings of fact, how does an appeals court treat findings of fact? Deferentially. They defer to them, D-E-F-E-R. Why? Because whether it's a jury or a judge, the witnesses who are testifying, well, the appeals court, they just have a written record. But the judge or the jury, they got to see those witnesses live, evaluate their credibility. So if findings of fact are made by the court below, whether it's a judge or a jury, there's a tendency, and it's a required tendency really, there's a rule, a standard of review. It's a difficult phrase sometimes, standard of review. And that is that you treat findings of fact subject to a standard of review that is deferential. It's called the clear error standard. Findings of fact will be upheld unless they are clearly erroneous. You know, and there's even language relating to that. The appellate court must have a definite and firm conviction that a mistake has been made. Now, all these words to describe things, they're really just instructions to judges to do something, and the judges can cast them however they want. But the bottom line is, when you're dealing with issues of fact, and you're an appeals court, you're supposed to generally defer to findings of fact unless they're just so crazy that they're not believable, or something along those lines. But it's much more deferential, right? What about issues of law? If you're an appeals court, should you just say, well, the judge below, he knows the law, he got it right. Oh, she knows what she's doing. She went to Harvard, and I only went to Fordham, so I'll defer to those findings of law. No. An appeals court, your job is to address questions of law. So that standard is called de novo. I can write that one down since it's Latin. And it just means a fresh look. Novo meaning new. You look at it like it's new, like it's the first time you're looking at it. So on appeal, the standard of review for questions of law is de novo. It is reviewing them very, very much as if it's the first time. You can defer to the findings of fact. You can assume the court below got the fact findings right. But when you're looking at questions of law, you really start fresh. You examine everything from the ground up. You know, any assumptions made about the law, any case citations, any general principles, any logical arguments, any judgment, because judgment is part of the law. Now you're beginning to see maybe where this relates to proximate cause. Right? Proximate cause is a determination that is partly a finding of fact and partly a finding of law. Right? We went over that in the first half. Proximate cause, there's the question of fact, but for causation. But then there's the judgment part. Do we hold the actor accountable for that event, given the number of steps between event A and event Z or whatever, right? So there's a component of proximate cause that is judgment, which means there's a component of it that's law, right? Now, if a judge on appeal is reviewing a question of causation, which standard do they apply? Anybody? Trying to get sounds going because this is a very still room. We need more activity. We need drum beats, dancing. I have to modulate my voice so that there's not only one monotone. Anyway, obviously, the thing that would make sense is for the appeals court to treat proximate cause as two things. The factual cause being one part and the judgment as to whether it extends that far being the other. Now, I will tell you this, because I had this issue after the QE2 grounding in the 90s, and we tried to go up on appeal, and I was arguing all this stuff. It didn't actually go to the Supreme Court because I wrote the petition, but they never filed it. But that's because the client didn't pay. Anyway, bottom line is, I wanted this to go to the Supreme Court. Why? Because I will tell you a little secret. Every federal appeals court in the United States, all of the circuits, 1 through 10, plus the other ones, the federal circuit, they all treat proximate cause as purely a factual question. So for purposes of appeal, they will defer to the lower court's findings of proximate cause. Really, they should defer to the lower court's findings of factual cause, but they should treat the judgment portion on proximate cause as de novo. But they don't. It all goes back to a case, believe it or not, a maritime case, and it applies in all areas of law, but it was a maritime case called McAllister versus United States. McAllister was not the tugboat company. McAllister was just a seaman. It was a government vessel. McAllister got typhoid, and it was due to, maybe some foreign gang crew, or foreign work gang that was working on board the vessel. He caught it from them over in the Far East, and the Supreme Court had one little line: questions of causation being subject to clear error standard. In other words, treated as questions of fact. And so the lower courts, I shouldn't say the lower courts, but the federal appeals courts all uniformly jumped on that one little line and said, we're going to treat all questions of causation as subject to the clear error standard and not de novo review. That's actually not good logic, but it's what the courts are doing. We have to defer to it, right? We have to give in because they have the power. I will tell you, it's not there. It's not the way it is everywhere. For example, in the state of Washington, the court system there is a very clear legal history where if there's a proximate cause question and it goes up on appeal from some Washington trial court, the Washington appeals court will clearly parse out which part of that determination was fact and which part is law. They'll say the factual causation part, we will defer to the findings of fact by the court below. But the judgment part of proximate cause, we will review de novo. So Washington State is one example where they do it, I would say, right. And what I was arguing in that case was that the Supreme Court should make our courts do it right too, but that never happened because we never filed a petition. But the bottom line is that here you had a situation, and I knew about it at the end of this oral argument. I knew about it when I wrote this article. Nobody anyway, but the bottom line is that he didn't even ask the question, but it's supposed to be in the briefing, and it's supposed to be on the court's mind. And in a case like this, you would think they would have asked, of counsel. What's the standard of review? How do we review Judge Baer's determination of fault here? Should it be de novo and we should defer to it? And of course, Sham Kimball would say, no, 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 Your Honor, because you want it reversed. And the other would say, yes, 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 Your Honor, because they wanted it to be reviewed. But nobody asked the question, nobody answered it. And in the opinion, it's an interesting opinion because they actually dodge the issue and come away around it, but they get to the same end. They do review Judge's application of the law, and they do review his use of proximate cause determinations. But they don't say they're doing that. They do a little dance with words. But the bottom line is that they surprised me. And the reason they surprised me is because I knew at the time when I watched this that the standard of review for proximate cause issues and fact cause issues in all of the federal circuits is clear error. And so it was a bit of a shocker that when I'm there at oral argument as an audience member, not only do they give an amazing amount of time, but they don't raise that issue. And then, amazingly to me, they actually do reverse Baer's determination of causation. And they don't say that they're doing it under the clear error standard because they probably couldn't get away with that because it wasn't clearly erroneous. I mean, it was, it had merit. I mean, his argument was they could have slowed down and they didn't. 100% on them. Meritorious argument. Hard to reverse on clear error. You can't say, there was clearly an error of fact if you treat proximate cause as a question of fact. But what they want to do was reverse it. But they didn't want to set a precedent that said, we're going to treat the judgment component of proximate cause under a different standard. So they did a little legal dance. In past years, I've uploaded the Second Circuit opinion and asked people to find, it's a lengthy opinion, but you'll find the paragraphs where they do this legal dance and say, well, we're not actually doing this, we're actually doing that. And it's a little wacky. But the bottom line is, that's why this case is interesting, because you have 100% of fault applied to one party. The standard on review should be clear error, according to what the courts say. In other words, even proximate cause should be reviewed clear error, according to what the courts of appeals do. But this one case, they decided to make an outlier, and they really did apply a de novo review to the proximate cause angle. That's exactly what they did. And they very carefully avoided saying that's what they did. So if you were a law student wanting to read, you were into the legal realist movement and wanted to read judicial opinions saying one thing and doing something else, this would be a great case study. But I bring it to you only because it's a great vehicle to introduce some really basic legal concepts that make a lot of law. And those are proximate cause and standard review. The two sides, and each one of those things is only like a paragraph, well, not a paragraph, 4 or 5 paragraphs long. Really short readings, it's on Brightspace, and it ties the two together in connection with this case. And it's really worth looking at because in terms of legal education, it gives you an idea of how courts do what they do. You know what I mean? Because courts don't do it once and then they're finished, right? Arbitrators might do that, because there's no appeals generally. But courts, what happens is, it starts off with a case. The case goes to trial. Findings of fact are made. Determinations of law are made. Then, assuming that it's going to continue, it then goes up to appeals courts. And then findings of facts are reviewed. And determinations of law are reviewed, but they're not reviewed the same. And a lot of times causation is an important question in the findings of fact and law for the reasons we discussed in the first half, because there's fact causation and there's proximate causation. And the way it all intertwines is kind of interesting because it's how law evolves, and it's actually what it affects our lives tremendously. I am going to talk about something tomorrow, and I'll just give you a preview because we're going to have it in our second half if we get far enough this afternoon, and it's a bunch of stuff about cargo. But what I was going to talk about is the way that this whole interplay between law and business and life in general works. You can't even separate them out. I mean, law affects the way business is done. Business affects the way law is done, and it's sort of a round continuum. And the example I'm going to give, not today, is in cargo, where you had this problem of carriers, they're taking on these goods. If anything goes wrong, they should be liable for everything, right? Well, that was the general law, but then all they did was write contracts and say, we're not responsible for anything if anything goes wrong. And that wasn't good either. And how do you make a bargain where you have millions of different players in millions of different transactions? The only way to do that is the legislature doing it, and that's exactly what they did, and that's what I'm going to talk about in my cargo section, which I did with my other section an hour ago, and we might get to this afternoon. But that one's, yeah, we'll do it this afternoon, we'll record it, because I didn't record that one. But that's sort of an evolving thing where you can see how business and law kind of work in this round-robin fashion. And even though it's not as obvious, this whole business about proximate cause and standard review affects how everything is done in the business world and in life in general. And it's a back and forth. It goes around. There's a play of, the one affects the other, then it affects the other, affects the other. So I just brought this out in the context of collision. Now the bottom line on all this, will you see this on the exam? Maybe one question. So we spent all, hour or so talking about it, and there's these two short handouts, but honestly, it's one of those classic cases of what, you can get out of a course by what you put into it, but you don't have to. You'll maybe miss one question on the final, and I'll probably have one question on this optional exam that's coming out on the 10th, but, and it'll probably be something basic, like the standard of review is A, a legal publication by Lloyd's List, probably not that. B, I mean, it'll be pretty basic. But the big picture here is much more worth grasping because it's how all this stuff interrelates. And the collision we studied is a classic case of how this whole stuff relates. So on that note, it's 4, and we're ending slightly early on my hour.